Yeah, hi, it's Roland Jones. So we're going to be covering an uncomfortable topic, which is possible racial discrimination in bankruptcy, or racial bias. I'm going to be talking about some studies that show statistically there appears to be a bias, but as we're going to see, there's not really a conclusion as to why that is. But there are suppositions that I'll go into. So the studies focus on Chapter 13, the choice between, and this is a consumer bankruptcy issue, the choice between choosing Chapter 13 or choosing 7. And this is one of the studies we'll look at, bankruptcy and race. There are numbers. Actually, this is an article, law review article, but there are a number of studies that have been done. And the issue is African Americans seem to be choosing Chapter 13 more than white people. White people seem to choose Chapter 7 more often than 13. And I'll talk about that a little bit from my own experience as far as the two consumer bankruptcy chapters. So this is statistical evidence that we'll go into, and it shows some strange results. I mean, and the question is, are lawyers steering black people into Chapter 13 where they have to repay debts over 5 years? Much more difficult way to go. Or are there other factors that are steering these folks into Chapter 13 as opposed to Chapter 7? Chapter 7, you don't pay anything over time and you get a complete discharge. It's a much better, there's just no argument that it's a better way to go. Well, but you can argue. I mean, the thing about Chapter 13 is you are paying a percentage of your debts off. And we'll go into why there may be either a religious or moral issue involved in this. So the report was called Race, Attorney Influence, and Bankruptcy Chapter Choice, Empirical Legal Studies. It's 2012 study, so it's recent. And it doesn't really reach a conclusion that's dispositive, but it does show that that black debtors are disproportionately placed in Chapter 13, which is much more expensive and burdensome. Right. So race is influencing it, but how? So basically, it's going to be comparing Chapter 13 filings and Chapter 7 filings among whites and among black folks in various different bankruptcy courts. So the bottom line conclusion is that after controlling for financial, demographic, and legal factors that might favor a Chapter 13 filing, so other variables, African Americans are much more likely to file Chapter 13 as compared to debtors of other races. Why would they choose a much more difficult way and much more lengthy way, much more expensive way, a much more painful way to discharge debts than just filing a Chapter 7? I mean, the thing you need to understand is in Chapter 13, and I'll go into this during the video, but you have to submit a budget to a trustee. So there's a third person that's approving your discretionary spending. So if you want to pay, a golf club membership, you can forget about it. I mean, I don't know, but I'm assuming that luxury items, or in other words, what's I think it's terrible about it is that it's invasive. I mean, someone's telling you how to spend your money and whether that's okay. And then, um, as I go into later in the video, it's a set amount that you've got to pay every single month. And, things happen, as everybody knows. Your car may need fixed. You might get sick. You have medical costs. And there's no change in the budget. You have to pay the same thing. So a lot of these plans fail. Most of them fail. And yet, African Americans choose this more than seven. You go to a 340. You go to basically not even a hearing. You meet with a trustee once, and you're done. And then you get a fresh start. But there are significant differences in not only Chapter 13 and variables why African Americans might choose Chapter 13, but as I go into later in the video, the bankruptcy code might favor whites in certain ways, and I'll go into that as well. So I'll adjust my camera. This slide is a little bit hard to read, but essentially what it says is that 54% of African American folks choose Chapter 13 versus 28% for white folks. So that's a huge disparity. Why would that be? So they did a study of consumer bankruptcy lawyers who represented debtors, and the study shows that attorneys were more likely to represent 13 when the hypothetical, obviously it's a test, when the hypothetical debtors were obviously African American sounding as opposed to white sounding. What's interesting is that they're more likely to recommend 13 for these folks, and the lawyers viewed the black folks as having better values and more competent when they preferred 13, as opposed to the white folks who were seeing as having better values and more competent when they chose 7. So what's that about? Well, it's not clear what that is about. But what is clear, even this is not clear, but it seems to be the case that unintentionally, perhaps, bankruptcy lawyers, and they don't break it down between, which I think they should have, between black bankruptcy lawyers and white bankruptcy lawyers. But it seems to be that they're slanted in how they view debtors, the race of the debtors, and what chapter these people should go into in bankruptcy, based on preconceptions about race. That seems to be a fair deduction. So as you can tell here, this is a chart of the responses from lawyers when posed a hypothetical question, and it's similar to the actual statistics. Whether a black debtor should choose 13 or 7, and most of the, well, not most, but 47% of the lawyers steered them to 13. And when no race was identified, it was 36, and with whites, it was 32%. So something's going on here, obviously. So the report concludes, which is pretty obvious, that the lawyers are making recommendations based on race, maybe unintentionally. There's no proof that there's an intention, or maybe that wasn't studied, I don't know, but they didn't find an intention or evidence of an intention. And they're saying it's likely unintentional. So it's not overt racism, but something's going on here. Well, I found this to be interesting, is that for blacks who preferred to avoid Chapter 13, is making, in my opinion, probably the right decision, the lawyers had negative impressions of that choice. or those folks. But when whites chose to avoid repaying debts in 13 over 5 years, they didn't have the same negative impression. So why is that? So we're quoting from the report, or the law review article about the report, basically saying it's unclear. Why would lawyers conclude that black couples should be kept in Chapter 13, even if they wanted a quick, cheap, and easy Chapter 7, which might make more sense? And why should white folks be protected from Chapter 13? Why should they be kept out, even if they want to pay their debts over time? No, the lawyers were biased in keeping them out of 13, even if they wanted to, even if they made a moral decision. We want to pay as many, as much of our debts as possible. That's our decision. It's no good. We want to keep you out of 13. So it's not clear why, blacks were, corralled into making a choice that did not appear in their best financial interest, and that whites were protected in that way, and they just didn't come to a conclusion. But we'll look at suppositions. Yeah, so to understand what's going on here, you have to understand that the bankruptcy laws changed pretty radically. Well, consumer bankruptcy laws changed pretty radically in 2005, when the means test was created. And basically what that is it's a test to decide whether you're going to go into whether you can file Chapter 7 or whether you must file Chapter 13. And that will play a role in the issue that we're discussing. So there was this was a political issue. There was a feeling that, before 2005, or before the events leading up to 2005, you could file Chapter 7, you could file 13, you could do basically whatever you want that was good for you. And, there wasn't a stigma to filing Chapter 7, and there wasn't any attempt to corral people into 13. I mean, there were financial reasons why you might want to file a 13, but it wasn't a forced decision. And the problem was that the media and Congress felt that people were acting immorally. There were stories about folks, racking up huge bills, and then at Macy's or Saks Fifth Avenue, and then filing a bankruptcy case and walking away and keeping luxury items. Stories like that. There were stories about people abusing the welfare system, not to work, all that kind of stuff. And so that kind of added up into political pressure to make a change. And so that was the background to forcing people into 13. Basically, in 7, you wipe out your debts, you're out. In 13, we're going to make you pay back some of your debts. So it's not going to be up to you anymore. If we think you need to pay back these debts, we're going to make you pay them back, or some of them. Yeah, so, that was the conclusion, but of some folks in Congress, but actually a lot of people disagreed with that. It was very contentious. And I was always on the side of, this is political nonsense. I mean, people who file for bankruptcy, Chapter 7 or 13, they file for a reason. No one files, I would say no one, but very few people file Chapter 7 or any kind of bankruptcy unless they absolutely have to. It's usually the last resort. There may have been some abuse, and I have no doubt, and I did personally see some abuse, but it's rare, very rare. Most people don't want to file bankruptcy, so I think the whole thing was overblown. But anyway, So after 2005, there's mandatory there's steps that need to be met. You have to do pre-petition counseling. There's more reporting, and which I'm going to go into in a second. There's the means test. Are we going to let you file Chapter 7? Are you broke enough for Chapter 7? Or can you pay anything off? The broke enough test. And we're going to make you take a means test. I think this whole process is not only invasive, not only patronizing, but just downright unkind. People who need to file bankruptcy shouldn't have to go through this, which is my opinion. So this is the means test. Are you broke enough? If the debtor's income is below the median income for households in the debtor's state of residence, the debtor passes. Congratulations, you passed the first test of being broke enough. The test, they passed the test, is deemed good and eligible for Chapter 7. There you go. Debtors above the median, you're making too much money, guy. Cannot receive a Chapter 7 discharge unless their income minus expenses show that they do not have the ability to repay their non-priority unsecured debts. So, typical credit card kind of debt over a 5-year period. So you've got to prove that you cannot file, that you're broke enough to file Chapter 7. And you can imagine all the manipulation that goes into this. And then trustees are appointed to review documents and review your income, review your expenses, and very invasive. Don't file 13 no. I take that back. I can't give any legal advice, and I don't know your situation. I'm not going to say don't file 13. I'm just saying 13 is a lot tougher, and that's the whole point of this entire video. So, and this isn't a video about Chapter 13, so I'm simplifying, grossly simplifying, but if you could pay 25% or more, you're probably going to have to, over 5 years, you're probably going to have to pay, you're probably going to have to file a 13 under the means test provision. Again, I'm simplifying. So again, if you could pay not all of your unsecured debts, not all your credit card debts, which is typically the debt we're talking about, or medical debts, but if you could pay some of them, 25% or more over a 5-year period, you belong in 13 according to this. If you cannot, then you've earned the right by being broke enough to file Chapter 7. There is a kind of ridiculousness to this. So again, it's a congressional bias on these theoretical legions of people that are filing bankruptcy to abuse the system, which probably never happened. So they're going to make Chapter 7 harder to navigate, and you better be really broke. If you're not broke enough, then you got to repay some of your debts. And we're going to make that decision for you. Why? Because the great unwashed doesn't have the moral capability of doing that. So we're going to make the decision for you. Us, in Congress, we're going to make the moral decision. There we go. I wonder if there's a study of how many people in Congress ever chose or were in Chapter 13. I'd be interested in knowing that. Probably zero. And again, it's to create a stigma. It's to tighten up on the bankruptcy system and reward people that are really broke with a chapter 7. If you're not broke, you get punished. You have to do 13. Not really, but you have to pay back some of your debts. I will say I have seen some abuse. I mean, the abuse that I've seen, and it hasn't been a lot, is that some folks do charge up a lot of stuff, and then they try to game the system. I mean, there are ways that creditors can file non-dischargeability complaints and render that debt non-dischargeable, but there are still ways. There were still ways of gaming. There probably still are ways of gaming the system. I don't practice consumer bankruptcy law anymore. It's been a long time since I did that, but there are always ways of gaming the system, and I'm sure this system is also being gamed. But another abuse is folks that have very significant income and filing Chapter 7 on big debts, and then walking away and then still having this huge income, and so timing it properly. But even folks like that, I mean, I would say typically in my experience, it's a tragedy. People don't do this. Normal people, except for gamers, don't do this. So this is I think this was a bad change in the law. Right. Basically, there's no more stigma in Chapter 7, so we're going to create one and stick you in 13. So the second report might show that lawyers were viewing black debtors, black folks, in a more negative light with respect to this choice, with respect to the choice of filing 13 or 7. Well, there you go, the whole welfare thing, scandal, whatever. And I'd be interested in knowing during this time how many of these congressmen ever experienced that kind of financial tragedy where they had to file bankruptcy or go on welfare. Zero. Yeah, so the study concluded that the bankruptcy attorneys started to view black debtors, black folks, African American folks, not white folks, with the same negative light that the Congress was viewing all debtors at the time of these debates, and welfare recipients, lumping them all together. You file bankruptcy, you go on welfare, it's all the same thing. But for this video, what's interesting is that how come white folks are not viewed in that similar light? Yeah, so this is the law review article by Dickerson, Bankruptcy and Race, Is There a Relation? That's a 2012 article. So it's not the study that made this conclusion, but the law review article is considering the possibility that Congress was viewing black folks that filed 7 that they didn't deserve the discharge. They should be filing 13, trying to pay back some of their debts. That attorneys were having the same attitude as maybe Congress was, if Congress was having that attitude, which is not clear. It was certainly not clear that Congress was discriminating or having a bias against African American debtors as opposed to white debtors. But we are faced with a significant statistical difference, and that's the problem. So what's going on? Is it lawyers that are viewing African Americans as it says here, abusive and opportunistic, and or is there something else? Okay, now we go into what I would call is maybe unintentional, maybe unconscious outright prejudice, but maybe outright and conscious prejudice. But research shows that white jurors presented with virtually identical fact patterns were less likely to believe in the innocence of a non-white defendant. And the supposition um, that it's possible that white bankruptcy lawyers faced with the same financial fact pattern are concluding that black debtors should file 13. They should, it's not moral. They should file 13, pay some of their debts, so they're ripping off the system. But when white debtors have the exact same financial situation, it's okay for them to. They're not gaming the system. They deserve a fresh start. Um, that basically says the same thing. As again, they're trying to interpret what's going on with the statistics. There's no evidence of causation. All right, so let's say we find that lawyers are steering black folks for what they think are moral reasons at the 13. The problem is the outcome is very significant, and I don't know if you would say bad, but it's going to be much more difficult for black folks. And for one thing, it's more expensive. So trying to get out of financial trouble, you don't want an expensive solution. You don't have money. That's why you're filing bankruptcy. And yet 13 is significantly more expensive and a burden. So we're going to compare 7 versus 13. 7, it's short, it's fast. You don't have to see a judge. Typically, it's an administrative hearing with a trustee. You only keep exempt property under applicable state law or bankruptcy law. And 90% of the cases are no asset cases, and you get a discharge. You basically go to one meeting called a 341 meeting, and fairly painless process. There may be a small percentage that involve proceedings and assets and stuff like that, but very, very small. And compared to 13, you just spend a lot less time dealing with it, and a lot less money. Also, the attorney fees are lower, which is something that, again, you don't have money. That's why you're filing bankruptcy. So the cheapest solution, the fastest solution, the easiest fresh start is always going to be the best. And it's going to be probably a Chapter 7 in a lot of situations. Chapter 13, you're stuck there for years. You're trying to pay a percentage of your debts. You're being invasively reviewed, approved, examined. Your personal budget is being maybe being criticized or changed. Much different. Definitely the legal fees are going to be more. Everybody knows that. It's also something that doesn't work a lot of the time. Because like I said before earlier in the video, things change. You have a budget. It's not that flexible. And they typically lasted 3 years, not 5 years. And it's supposed to be 5 years. So maybe appropriate for some folks, purely on a financial basis. But for a lot of folks, probably not appropriate. So, unfortunately, they started sticking people in 13, 2006, after the 2005 change, 2006, 2007. Of course, the country went into a major recession, depression, whatever you want to call it. So that made things even worse for Chapter 13 debtors. Chapter 7 debtors, they're out. Get a discharge, start your life over again. It is more difficult for folks that are in more of an unpredictable job situation, where their income is less predictable, people making less money, um, and as opposed to let's say someone making a ton of money and then has no assets, then they get a discharge and they're good to go. But if you have an unpredictable income and you're filing 13, you're trying to pay creditors a little bit, you're going to be filing, you're going to miss you're going to miss your budget, and then what? Then you don't get your discharge. The whole thing's a waste, and you have to file again. There you go. You pay your debts for a couple of years. You're in the system, and you get nothing. Nothing. It's very tough. Much different than Chapter 7. Much, much different. So pro se filings, pro se means without a lawyer. So folks that don't want to spend the money on a lawyer, which makes sense. You don't have any money. Why would you want to pay? I mean, it can make sense for certain folks. I'll put it that way. Um, why? Because you save money. Save money after your discharge. If you're in Chapter 7, after your discharge, you have more money for your fresh start. Well, there was a dramatic increase in people filing their own bankruptcy petitions after 2005. I think that probably has to do with the recession more than anything else. However, most people, the large majority, still use a lawyer, and properly so in most circumstances. It's a big decision you're making. There could be implications, complexities. You want to get it handled right. The other problem is that with the means test and more paperwork and more bureaucracy, you really need a lawyer to guide you through all that stuff. So after the 2005 amendments, it's even more important to have the right counsel. So you want your lawyer to help you, but what's concerning is that what these studies may show is that some of these lawyers may be biased depending on the color of your skin, maybe guiding you in the wrong direction, or maybe not. We'll see. There are some other issues. There's some other variables, and we're going to go into the variables now. Well, the first reason is if you have a white bank, they don't really. The study doesn't go into white versus black bankruptcy lawyers, but if you have a white bankruptcy lawyer and you have an inherent prejudice just because you don't know many black folks, then you may have different, to give them the benefit of the doubt. The benefit of the doubt, it may not be conscious. You just don't know these folks as well as your own kind. And so, the solution to that is getting it, making more personal contacts. And the problem is that, people tend to end up in their own worlds, their own schools, different workplaces, neighborhoods, etc. All right, well, that's pretty obvious. Yeah, so again, it's all speculation. The study does not go into that, whether they're white lawyers or black lawyers, whether the white lawyers knew a lot of black folks or didn't know a lot of black folks. It's just speculation that might be a variable. Who knows? No explanation. Yeah, so the point of this slide is that, these are, in some of these places where there's a very high proportion of 13 filings by African American folks, there's a lot of African American folks all over the place. 79% of the population is black. So it doesn't really explain that exposure or lack of exposure is the issue. Um, in these areas, that variable doesn't seem to be an issue, or probably shouldn't be an issue. I guess you could argue that maybe it's a white lawyer in some kind of like gated community, and he drives from his gated community to his office and only sees white people. But I find that a little bit hard to believe uh, in uh, in Jackson, Mississippi, where almost 80% of everybody is black. So it kind of doesn't make that the lack of exposure variable is kind of defeated by that. Here's another statistical presentation on different districts, different states, and actually different bankruptcy districts, and the variation between African Americans filing 13 and whites filing 13, and it's huge. You can just tell by eyeballing this. But it doesn't seem to vary on whether on the state that much, or where the state is, if it's north, if it's south. Um, it doesn't seem to be correlated that way. It's no, I mean, you can notice that in Michigan, there's less of a difference, 37% versus 31%, than there is in, maybe some other states, by eyeballing this. But it doesn't seem to indicate anything. It doesn't seem to provide us with a conclusion as to why. Okay, another reason, so-called paternalism. Yeah, so this is again a supposition that lawyers believe that 13 is best. Obviously, they think it's better for their African American clients and worse for their white clients. So why is that? Well, one reason, and it's a very obvious reason, in 13, it's easier to keep property, such as a house, and then stretch out arrearages on mortgage payments and that kind of thing. I mean, the lawyer's fees are higher, but you can spread them out. But keeping property might be a big deal, especially if your income is a lot less and it's a lot harder to get a mortgage to start with. It may be a good decision uh, to file 13, just to keep your property and spread out the debt, the applicable debt, and have a chance. Because, and I'm going to go into that later in the video, is that it may be harder for African Americans to get credit, especially if they have lower incomes, or for another reason. Another reason, which is not really a reason, is that yes, 2005 amendments. The concept was to require more people to file Chapter 13, but empirically, statistically, hasn't been the case, and it would not explain why more black folks are filing for 13 than white folks. I mean, they're less broke than white folks. It just doesn't make any sense at all. Yeah, so this is interesting. Some debtors might file 13 out of a sense that it's better to repay creditors. It's more, it's a personal decision, but maybe some people think I'd rather pay some of my debt than just get a discharge of all my debt. That's a decision I'd rather make. There's a famous story about Abraham Lincoln who went broke in his first business. It was like a small 7-Eleven type store. Went completely broke, and he was paying off that debt when he was in Congress. He called it the national debt. So some folks make that decision, and that's fine. Do black folks make that decision more than white folks? Are they more moral than white folks? Maybe. Well, what's kind of tricky here is, what's the job of the lawyer? The job of the lawyer, I think, is to tell you what's in your best interest, legally, financially. His job is not to promulgate morality in any way. It's your personal decision. And so that may be maybe these lawyers are advising black folks to file Chapter 7 because it's a better financial decision. Maybe these folks are just saying no, we don't feel it's morally right. Or again, it could be because they think it's they're going to have more credit. They're not. The lawyers are not discriminating, but they recognize that black folks, African American folks, are going to have a harder time maybe getting credit. So it's a better financial decision to file 13. Maybe that's going to impact the availability of credit. And the fact is that credit scores are overall statistically lower for African Americans. It's beyond the scope of this video to go into why, but that's appears to be a statistical fact. Just pick up the paper and you'll see that African Americans have a harder time getting car loans and in a wide variety of situations, getting houses, renting, even buying houses. So, the lawyer might be saying to himself, I better put these folks into 13 because that's going to help them. They don't have to apply for another mortgage, go through that hassle. They can keep the house, and maybe that is the better decision. But as this law review article points out, it's not clear why lawyers are doing this, and there is a study that lawyers are making a moral judgment that African American folks should go into 13. If they don't, they think less of them, and the opposite for white debtors. Yeah. So another reason is expanding on the moral issue. So religion can play a big role in your actions, what you're going to do, especially with respect to debt. And those views on debt and debt repayment are powerful in religion, and that there's a moral obligation there. So this is an interesting article, putting the site in there, about Amish and Mennonites facing financial crisis. And if they were to file, they'd probably file in 13. Something to consider. So what this law review article says is that if we just divide it up by religion, then that would ostensibly provide a race-neutral explanation, if that was done. And as you can see, this law review article that was cited in the article about a 713 divergence is that African Americans spend a lot more time in church. They're a lot more involved in religion socially and on an everyday basis. So under that hypothesis, the culture, if the lawyer is part of that culture, which hasn't been statistically analyzed, then if it's an African American lawyer, maybe he would steer African American clients more to 13. But despite this, the question is, what should a lawyer do? Even if clients are African American and have a strong feeling about morality, should the lawyer push them? Should the lawyer be neutral? Should the lawyer push them into 7 and make arguments as to why Chapter 7 is better? Some people say yes, or maybe it's the lawyer's job to, what I said before, advise the client on what the best financial and legal course is, and leave moral decisions, which is a factor, up to the client. So this slide is basically about that debate and what articles have said. Yeah, so I think this is less likely, but most judges are white. There may be prejudice there, maybe lack of contact, trustees. I don't think judges aren't a factor because you don't really have any contact with a judge in consumer bankruptcy in a lot of cases. But you do have a lot of contact with a trustee. But you've typically already made your decision whether you're going into 7 or 13, although the trustee may object to your 7 case and force you into 13. So that's possible. So there's no reason to think they'd be less biased, but I don't think judges really play a role here, but trustees might. Okay, so this came from a law review article about unconscious racial bias in judges, but again, in consumer bankruptcy, you're likely not to encounter a judge. So yet another try to explain the statistics, this time by saying that your lawyer is anticipating the racial bias of a trustee or a judge, so he's going to tell you to file 13 instead of 7 because they're going to stick you in 13. I don't know. I think that's very hypothetical. But there's another wrinkle. There's another possibility. Yeah, like I said, judges and trustees not going to be involved too much. But trustee is going to be somewhat involved. Not a judge, but trustee. Right. But you are going to have to meet up with a trustee, so maybe a factor. True. But in the last hypothetical, it's possible that your lawyer may be anticipating what you're going to face if you're African American, maybe making a decision based on that. Yeah, so financial illiteracy is another issue. Understanding what's going on with your finances. Most people have no idea what they're doing. But the lower income you have, and unfortunately, non-white households seem to be even more ignorant about financial decisions and the risks associated with those decisions, which could play into this decision making. So, statistically, African Americans seem to have a lower level of understanding. Yeah. So apparently this happened as well, which is really tragic. People losing their homes because they don't understand. We're going to take a second mortgage and take money out, but there's less security. And this slide could show very, very terrible consequences of not understanding financial implications, the implication of financial decisions, put it that way. Is that similar to choosing 13? I don't know. I mean, I don't think anyone knows, but it does seem to be different when you're choosing 13. You may be making a moral decision influenced by religion. Okay, so another example of financial illiteracy, probably. Well, that's another thing. I mean, it's just a lack of sophistication. But does that translate into choosing 13? Doesn't seem, in my opinion, doesn't seem to be closely related because you have a lawyer explaining. You should have a lawyer explaining the differences between 7 and 13 very clearly. If he's not, lawyer's doing a disservice. Okay, We're beating a dead horse. Right, just because whites theoretically are more sophisticated, that doesn't explain why black debtors would disproportionately file 13 cases. Okay, so this is interesting. The bankruptcy code. So how is the bankruptcy code rigged up in favor of white debtors? Well, the theory is that the code was drafted by white folks, and that these folks had similar financial lives as potential debtors, and these white potential debtors were favored. Yeah, so it favors someone that's married. It has someone that has few non-dischargeable debts, like student loans. I don't know how that's a white versus black thing. A lot of whites have student loans. Has stable employment. Arguably, maybe whites have more stable employment and disposable income. And has wealth concentrated in assets that are protected. Employer provided retirement plans. Whites might have more of that. IRAs, KEOG plans. I don't know, but there's a supposition that the bankruptcy code is rigged to favor a white person's financial background more than a black person's. Yeah, that's what this law review article says. I don't know if this has been statistically proven. That whites have lower student loan debt. Who knows? Probably statistics on that. I haven't seen them. Maybe higher home ownership rates, maybe larger retirement savings. That's possible. Higher household income is possible. It's beyond the scope of this video to analyze and question this, but there is an article, and you can certainly read it, and that's the citation. Okay, so we get to this uncomfortable but real implicit racial biases that people aren't aware of, but that are there. Unconscious associations. So what we said so far is that maybe racial steering is intentional and explicit, but maybe it's not. You have a white lawyer and a black client, just some kind of bias there leads to a recommendation to go into 13. I don't really see how that makes a lot of sense, but there's another possibility. Okay, understand that. Yeah, that's true. Judges are mostly white. So what? They're not involved in the decision to enter 13, to go into 13 or 7. So I don't see how that's relevant. But it's information that may be relevant. Okay, how to cure bankruptcy lawyers from being racist or implicitly racist or giving racist advice. How do we help these people? Well, you got to know what you don't know. If you don't know you're acting out of an implicit bias, then you got to be aware of that. Again, I just don't see this. I think there are better explanations for the 13 filing, the over 13 filings among African Americans, but not impossible. I think this does explain why some lawyers I mean, why would some lawyers, view white people more positively for not filing 13 and view black people more positively for filing for 13? I mean, that to me might be an implicit racial bias, but that may not be why African Americans are filing for 13. There may be a moral reason, maybe other reasons, like we discussed. So here's another way, be aware, be mindful, know how your perceptions. So anybody watching this who's a consumer bankruptcy lawyer is going to think twice about recommending 13. I'm sure about that. Going to think twice about recommending 13 to an African American couple that walks in the door, and then not recommending it to a white couple that walks in, 20 minutes later. So you can't say you're not aware now. You've been told there's a problem here, or there may be a problem, or maybe it's not a problem. Maybe it's a choice. Maybe it's a decision based on religion. But you should be aware, you are aware now that this is a statistical reality. Okay, so more exposure, taking the other perspective, whatever that means. Okay, so getting to know people that are not like you, getting to know African American folks, if that is going to help deal with your implicit bias, getting to know other cultures, obviously, that will always help. If there is an implicit bias, if that's causing more 13s. Well, if you're a consumer lawyer and you're doing a lot of consumer law, it's easy to take a look. Are you recommending 13 to African Americans more, or than your white clients? I mean, now that you've seen the statistics, you're certainly able to reconsider that if it's appropriate. It may not be appropriate. The video does not come up with clear causation determinations or conclusions because they're just not out there. Conscious, to me, that's more of a conscious decision. And like I said, anybody watching this is going to be more conscious, or not watching this, but reading some of the many articles out there that have shown up frequently. Use a checklist. Okay. Okay. Explain your decisions in a rational way. And again, there may be a rational decision. It may in fact be a better choice for some folks and for African Americans. But each case is different. Each case has to be analyzed to decide whether it really is a better choice, because it's a significant decision. It's certainly a much more difficult process, but is it worth it? So you don't have to apply for a mortgage again? It may very well be worth it. It may be much more of a hassle to lose your house and go through that whole process again, and that may be more chancy. And maybe it's even riskier. Maybe it's less risky to stay where you are and keep your house, if that's the situation. We found this article. You should also be aware of micro-messaging. Not sure what that is, but keep an eye on it. Okay, so this is the last slide in the video. I think the lesson, there are a lot of lessons to draw here, and there are a lot of conclusions not to draw. It's very difficult to tell why this statistical difference exists between 7 and 13. for practitioners, for people considering filing bankruptcy, um, be aware of it, be aware of the statistical issue, and make very conscious decisions. I think for lawyers, you have to justify, have to have a rational basis, and for your recommendation to go into 13, which I'm sure you do, but I think you have to be even more careful um, given this information. And for folks considering bankruptcy, whether you're black, whether you're white, any other race, you have to be aware of the financial implications, the long term and the short term, while also taking into account your own personal morality and your own personal decision on whether you wish to repay some of these debts and go through the expense and pain of doing that.